Good afternoon, welcome to VANIK-IAS, and we will discuss current affairs of 13th August and first we will discuss objective questions. Consider the following statements with reference to Criminal Procedure Identification Act. Right? Which of the following are correct? Right? Unlike Identification Prisoners Act 1920, the new Criminal Procedure Act provides for legal sanction to law enforcement agencies for the collection of the measurements. Yes, it provides legal sanction to the law enforcement agencies. It provides legal sanction to the law enforcement agencies for the measurement. That means police can take the collection of measurements, that is, for example, biometric or all the details of the convicts. The act is designed by designated National Crime Records Bureau (NCRB) to manage, process, share and disseminate the records collected at the state level. Yes, all these things data regarding crime will be managed and processed by the National Crime Records Bureau. So both the statements 1 and 2 are correct. Okay. Consider the following state actions which government can take. That is devaluating domestic currency, reduction of export subsidy, and that is adopting suitable policies which attract greater FDI and more funds from FIIs. Which of the above actions can help reducing the current account deficit? Current account deficit means when it will increase, that means when our imports will be more than the exports, our current account deficit will increase. So first, when we devalue domestic currency, devaluation means, suppose for example $1 earlier it was 80 rupees, now if earlier it was 70 rupees, suppose $1 is equal to 70 rupees and it is increased to $1 equal to 80 rupees, we can say it is devalued, right? Devaluation happened. But in case of free floating regime, devaluation is not happen. It doesn't happen. In case of India, it is free floating regime. But if we will devaluate our money, so what will happen? The exports that will boost our exports, right? When we devaluate our money, that will boost our export, right? And that will address our current account deficit. So this is right. Next, when we reduce the export subsidy, right? When we reduce the export subsidy, that means it will our export will not become competitive. So export will be less, and when export will be less than the imports, obviously the current account deficit will increase. So this will be wrong. There should be given export subsidy. We should promote export so that when export is promoted, the current account deficit reduces. Then adopting suitable policies which attract greater FDI and more funds from FII, right? Greater FDI. If FDI will come, means foreign direct investments will come. They will come in dollar. Obviously, the investment they will demand more. They will give dollar to the RBI and they will demand for the money. That's why the demand of money will increase. So and they will give dollar to the RBI. That's why the current account deficit it will reduce. So 1 and 3 option will be the right answer. 1 and 3 option will be the right answer. Consider the following statement with reference to National Crime Records Bureau. National Crime Records Bureau (NCRB), that is the nodal agency regarding crime, which process the data and also structures the data and provide all the information regarding crimes. That is NCRB. It has been entrusted to maintain national database of sexual offenders. Yes, all the type of database it has NCRB, and share it with the states on regular basis, right? It will share the data with the states on regular basis. NCRB is a statutory body and functions under Ministry of Home Affairs. No, this is nodal body. This is not, it's a nodal body regarding crime, but not statutory body. So NCRB is not a statutory body. So second option is right. So 1 only is the right answer. See, the data of NCRB are based on the state, because state and law and order is a state subject. So data that is processed by NCRB are primarily taken from the state. Next, the term PFM1 and PFM1S. What is this PFM1 and PFM1S? They are called as butterfly mines. Butterfly mines. Butterfly mine means that will blast a person when someone will step up or come across this. That will what they are called as butterfly mines. It is primarily deployed by Russia. It is found by the UK intelligence that maybe this PMF1 and PMF1S, which are anti-personnel mines. Anti-personnel mines means if a mines would step on it, that will blast. Anti-personnel mines, that is PMF1 and PMF1 and PMF1S, right? Anti-personnel mines. So D is the answer, which may be UK. The UK intelligence doubt that Russia has deployed in the region of Luhansk and Donetsk, right? That is anti-personnel mines, that is PMF and PMF1S. Consider the following statement with reference to Ottawa Convention. What is Ottawa Convention? Ottawa Convention can't use anti-personnel landmines. Members of Ottawa Convention cannot use anti-personnel landmines. Yes, this is right. India has signed the treaty. What, not ratified? No, this is wrong. All the borders sharing neighbor country of India signatory to the treaty. Whenever you see the word all, like, this is wrong. So only one option is the right answer. Ottawa Convention, they cannot use anti-personnel landmines. That is in news because of PMF1 and PMF1S, which is doubted that Russia is using those anti-personnel landmines. Consider the following statement with respect to UNCTAD report. UNCTAD report on cryptocurrency, which is in the news, right? United Nations, this UNCTAD report. The Ukraine population had highest digital currency ownership. Yes, because highest digital currency ownership, Ukraine population has highest digital currency ownership. India holds the 5th position. No, India holds the 7th position, right? India holds the 7th position in possessing digital currency. So one only option is the right answer. This is wrong. Around 7.2% of India people are using, 7% people of India are using cryptocurrency. Remember, cryptocurrency is based on blockchain technology, which is highly secure. Cryptocurrency is based on the technology underlying cryptocurrency is blockchain technology. Blockchain technology. Right, blockchain technology on cryptocurrency, and it is highly secure. Right, it is highly secure. Blockchain technology or cryptocurrency is highly secure, but highly volatile as well. Volatile means maybe the currency may flow from one country to another country at any time, right? It is highly volatile. Cryptocurrency is highly volatile, having no central authority, right? Having no central authority. Cryptocurrency do not have any central authority. That's why they are volatile. They may affect the monetary policy of a country, right? They may may affect the monetary policy of a country. These are cryptocurrency. Okay, global employment trends for youth report. Global employment trends for youth report is published by which organization? So global employment trends for youth report, it is published by International Labour Organization or ILO. International Labour Organization publishes global employment trends report. Next, World Elephant Day. When World Elephant Day is observed? It is observed on 12th August. World Elephant Day is observed on 12th August. Next, with reference to Indian elephants, consider the following statements. The leader of an elephant group is a female. Yes, the leader of an elephant group is a female, and the maximum gestation period can be 22 months. Gestation period is maximum 22 months. An elephant can normally go calving till the 40 years only. No, it can go up to 60 years. It may give birth up to 60 years, right? All the states in India, highest population in Kerala. No, it is in Karnataka. Karnataka has highest population of animals, of elephants. Elephant, it is IUCN endangered, right? Its status is endangered. The status of elephant is endangered in IUCN status, right? IUCN endangered species. It is protected by Schedule 1 of Wildlife Protection Act. It is important species. It's called, it is a keystone species, right? It is a keystone species, means it's keystone species means those species which whose role in the biodiversity is of the highest. Tiger, lion, these are keystone species. IUCN status is Schedule 1. It is protected under Schedule 1 of the Wildlife Protection Act. Endangered. Its IUCN status is endangered, right? Okay. World Drug Report. Who releases World Drug Report? UN Office on Drugs and Crime. World Drug Report is released by UN Office on Drug and Crime. Next. Consider the following statements regarding Centre's guidelines on regulation of groundwater extraction. Center guidelines on regulation of groundwater extraction. Now we are facing, India has a population of 17% of world population, but having 4% of the water resources that we have. So there is a gap of 13% of demand and supply. So that's why there is a groundwater pollution, there is over extraction of groundwater, there is also problems like pollution, groundwater pollution, over exploitation, and the water level is goes down gradually. These are the issues regarding groundwater. So India has some regulation regarding groundwater extraction. India uses most groundwater. India uses most groundwater in the world. Yes, especially for the irrigation purposes and for urbanization purposes, India uses most groundwater in the world. The guidelines exempts domestic consumers, farmers, MSMEs drawing water up to limited from the NOC requirement. Exempts domestic consumers, right? They can extract groundwater. Farmers and MSMEs, right? But the large companies, they have to take the permission, right? Next, non-compliance of NOC conditions may attract a penalty between 50,000 to 10 lakh. So whenever you see the word may, then there is chances that they are right. Here all the statements are right with respect to groundwater extraction. So 1, 2, 3, all the options are correct. With reference to International Court of Justice, consider the following statements. The ICJ is the principal judicial organ of the International Court of Justice. Yes, ICJ, principal judicial organ, right? International Court of Justice. Now we have the judge, Justice Dalbir Singh Bhandari in ICJ. It was established in June 1945, right? Along with the, it is also a World Bank and IMF also they are established in 1945. ICJ has 15 judges who are elected 9-year terms by the United Nations General Assembly and Security Council, which vote simultaneously but separately, right? ICJ has 15 judges, right? So all the statements are right here. It has 15 judges and India has Dalbir Singh Bhandari and its judicial organization of United Nations. It is established in 1945, right? World's largest cargo aircraft named Antonov An-225 owned by which of the following countries? Antonov An-225 is owned by which of the following countries? It is, yes, largest cargo aircraft. Largest cargo aircraft Antonov is owned by Ukraine. Ukraine has the Antonov An-225. Consider the following statements regarding the species dugong or sea cow, right? It is called as, also called as sea cow. It is seen in the Gulf of Mannar on Parkway. Yes, the dugong is endangered species. It is an endangered species and that is under the species has IUCN status endangered and they are protected under the Schedule 1 of the Constitution, Schedule 1 of the Wildlife Protection Act. Dugong or sea cow, it is endangered species by IUCN and right and Schedule 1 of the Wildlife Protection Act. Next, A dugong and calf were first sighted in Pak Bay and Gulf of Mannar in 2018. Yes, it is first sighted in the Pak Bay or Gulf of Mannar, that is just between India and Sri Lanka. That Pak Bay or also that is called as Gulf of Mannar. Right. So both 1 and 2 of such statement are right regarding dugong or sea cow. Okay. Next. With reference to Montreux Convention, consider the following statements. Montreux Convention, it is signed in 1936. It is international agreement governing the Bosphorus and Dardanelles states. Where is the Bosphorus state? See, it is near the Black Sea. Suppose this is Black Sea, right? Here is Turkey, and here it is your Russia. Here it is Ukraine. Here it is Georgia. Then your Moldova, Bulgaria are here, and here there is your Bosphorus Strait. Bosphorus Strait and Dardanelles. Here it is your Sea of Marmara. Here it is Sea of Marmara and Aegean Sea. Aegean Sea and Sea of Marmara. Aegean Sea and Sea of Marmara. Sea of Marmara. Please go to the map. Marmara. Just above Marmara there is Sea of Azov. Sea of Azov. That area. And it is Sea of Marmara and Aegean Sea. They connect the Bosphorus Strait and Dardanelles Strait. They connect to the Mediterranean Sea. Right. Black Sea is connected to Mediterranean Sea. So Bosphorus Strait, Dardanelles Strait, and Sea of Marmara, through Sea of Marmara and Aegean Sea. Okay, Montreux Convention, it is not like it's 1936 and Convention International Agreement governing Bosphorus Strait and Dardanelles Strait in the Turkey, right, in the Black Sea region. Montreux Convention regulates maritime traffic through the Black Sea. Yes, maritime traffic through the Black Sea is regulated by Montreux Convention, right. There is also Montreux Convention in 1980s, that is for conservation of ozone. Right, there is ozone, Vienna Convention and Montreux Convention, Montreux Record, Vienna Convention and Montreux Record, that is for ozone. But here it is Montreux Convention, that is for regulating the maritime traffic in the Black Sea. Which of the following year was the Marrakesh Agreement? Marrakesh Agreement was established by the WTO. Marrakesh Agreement 1994, when WTO is created. Then WTO is created 1994. C is the answer. Next, which of the following statements Madagascar are true? It is an island country located in the Indian Ocean. Yes, it is West Indian Ocean. We can say it is West Indian Ocean. It is right. And yes sir, also admit card रे photo disappear. कौन करेगी कौन तू admit card रे photo disappear है सी. Okay. You should directly phone to the OPSC office, then ask the details and mail the same to the OPSC as well. And presently, if your photo is not mentioned in admit card, then you should write a mail to OPSC and call them once and follow the guidelines. Okay. Then which of the, yes, Madagascar is just in the West Indian Ocean, right? Just the right of the east side of the Africa. It is also world's second largest island. Yes, it is Madagascar. It is a country separated from African continent by Mozambique Channel. Yes, there is Mozambique Channel is present there. So it is located in Indian Ocean. So all the options are right here. World's second largest island and country separated from African continent by Mozambique Channel. Next, software and intelligence marketing based identification related to which of the following species? Asiatic lion, that is primarily found in the Gir forest of Kutch region of Gujarat, right? Software with intelligence marketing based identification, right? That is linked with Asiatic lion, that is found near the Bani grassland of Gujarat, which is the largest grassland of Bani grassland, or your Asiatic lion is especially your Gir forest, that both are very present in near the Kutch region of Gujarat. Kutch region of Gujarat. Kutch region of Gujarat, there is Gir forest where Asiatic lion is primarily found. Next, which of the following statements about furlough are true? Furlough, it refers to granting leave in the for absence of a it is granting leave of absence. Furlough, just a second. You can write in the comment section how exactly how exact number of questions you want to be discussed in this. We have a 2-hour session. We both discuss both some prelim facts and some mains topics. So exactly, if you have any choice, you can also write in the comment section how much questions should we discuss. We want your suggestions with respect to that. You may write it, right? Okay. Which of the following statements about furlough are true? Furlough, yes, it is refers to granting leave of absence for a specified time period to a convict from the prison, right? For a specified time period. Why it is given? Because our judiciary is like that. That is the beauty of judicial system, that a person has also some human rights, fundamental human rights. He want to meet his family members because unless he meet his dear ones or family members, what will happen? He will undergo various mental trauma and he will not be okay so far as mental health is concerned. Suicidal tendency will develop. So in a particular specified time period, it is granted, furlough is granted to the convict, right? To a convict from the prison. It is not a legal right of the prisoner. It is not a legal right of the prisoner. Yes, you cannot, say that it is my legal right. It's the discretion of the law enforcement or the authorities, the jail authorities, whether they feel that it is safe to leave you outside. Then it depends on them. It is not a legal right of the prisoner, right? The condition of granting these states it is a state subject and not the state list of the 7th schedule of the Constitution. Yes, it is state subject because law and order is a state subject. Law and order is a state subject, and as law and order is a state subject, so they are granted state subject. The conditions for granting furlough is especially depends on the states, right? Next question. With reference to Millennium Challenge Corporation, consider the following statements. Millennium Challenge Corporation, it is a bilateral United States foreign aid agency established in 2004. In 2004, yes, Millennium Challenge Corporation. Millennium Challenge Corporation, it is a bilateral United States foreign agency established by 2004. It is a government agency established by US government. See, this is bilateral unit, right? It's a bilateral, so it cannot be established by one government. Obviously, one option is the right answer. Next, we will discuss some prelims facts, very brief prelim facts. After that, we will discuss mains. What is this butterfly mine? Recently, we discussed butterfly mine, a question about butterfly mine. The UK Ministry of Defence, in its intelligence assessment of the ongoing war in Ukraine, Ministry of Defence, Ukraine has sounded alarm on the possible use of PMF-1 and butterfly mines by Russian military in Donetsk and Kramatorsk region, right? The conflicted region where Russia has now upper hand over Ukraine. So that is UK military defense, Ministry of Defense intelligence has find out this PMF-1 series. What is this PMF-1 series? What is this PMF-1 series? As per intelligence bulletin put out by UK Ministry of Defense few days back, the security situation in the Ukraine and Russia is likely have deployed anti-personnel mines. These are anti-personnel mines. Remember, this PMF-1, they are anti-personnel mines to deter freedom of movement along its defensive lines in the Donbas, right? In the Donbas region, freedom of movement, you cannot move because these are land mines. If somebody put his step on landmines, obviously he is going to be blasted. So that is done by, they are called as butterfly mine. Remember, butterfly mine or PMF1 or PMF1S. As per bulletin, these mines have potential to inflict widespread casualties. Yes, they have potential to inflict widespread casualties among both the military and the local civilian population. Obviously, the local civilian population are going to be affected because of the landmines and the butterfly mines. Donetsk and Kramatorsk, Russia is highly likely attempted at an deployment of PMF1 and PMF1S. Right. Attempted to deploy PMF1 and PMF1S, scattered anti-personnel mines. These are anti-personnel mines that will affect the human beings. Commonly called as butterfly mine. The PMF1 series are deeply controversial, indiscriminate weapons. They are controversial weapons. They are banned by international convention. A particular person they cannot use. This PMF1 and PMF1S. PMF1S were used to devastating effect in the Soviet-Afghan War. So it was also used in Soviet-Afghan War, where they allegedly maimed high numbers of children who mistook them for toys. Yes, this PMF1S, they mistook them for toys and they will blast. Right? There is a movie that is based on this Afghan War. That is Charlie Wilson's war. In that movie, they have explained how the children thought this is a toy and they will hold it and that will blast. These PMF1S that are used by the Soviet-Afghan War, by the Soviets, by the USSR, and the children they taken them by thinking that they are the toys. Its bulletin added that it's highly likely have Soviet era stock being used by Russia will have degraded over time and now unreliable and unpredictable. This poses a threat to both the local population and the humanitarian mine clearance operations. Obviously, it is a Soviet era stock. These mines are Soviet era stock, that is since the Soviet era times. What is this butterfly mines and why it is called? So the PMF1 and PMF1S, they are called as these anti-personnel landmines. That means if you step, you will blast. Are commonly referred to as butterfly mines or green parrots. They are also called as green parrots or butterfly mines. These names are derived from shape and color of the mines. They are green mines. Main difference between PMF1 and PMF1S is that the latter comes with a self-destruction mechanism which gets activated within 40 hours, within 1 to 40 hours. Right. PMF1S, what is PMF1S? They become self-destructed after within 40 hours. It will destruct itself. The butterfly mine has earned a reputation for being particularly attractive to children. Because it looks like a colored toy. That's why it is called as butterfly. It's like a colored toy. It is very sensitive to touch and thus just act of picking it up and set it off. So whenever you just pick it, that will blast. That is butterfly mine, that will blast automatically. Because of the relatively lesser explosively packed with a small mine, it is often injures and maims the handler rather than the killing them. That injures the persons, right? They do not kill, they injure the person, they will blast, they will cut the two hands, they will blast the two hands of the person who hold these mines or butterfly mines. These mines are also difficult to detect because they are made of plastic and heavy metal detectors. They are made of plastic and so metal detectors cannot detect them. They are made because they are made of plastics, butterfly mines. The rapid means of deployment of the mine and fact that it can be indiscriminately scattered to impede the advance of enemy makes it an attractive option in the field of commander. regardless of the danger that can pose for the commandants living in the area. So that will create a danger. They will not kill it, but that will make it blasted. That will blast with different parts of the body. Are these kinds of mines are allowed by international law? The anti-personnel mines are banned by international convention. Anti-personnel mines are banned by international conventions on land mines, but Russia and Ukraine are not signatories to it. Russia and Ukraine are not signatories to anti-personnel land mines, and Russia has also used in Afghan war, and also it is using with Ukraine. Right? There is 1996 amended protocol, the Convention on Certain Conventional Weapons Landmines Protocol, to which Russia and Ukraine are signatories. So they are signatories to 1996 amended protocol. In the ongoing conflict, both countries have accused each other of having used these mines, since both possess them in sufficient numbers. So both Russia and Ukraine, they possess this butterfly mines in sufficient numbers. Allegations and counter allegations of the use of these mines have been made in Mariupol, Kharkiv, and now Donetsk region. So they are being used by both by Ukraine and the Russia. Okay. Ottawa Convention. What is this Ottawa Convention? 1997 Convention on the use. It is a 1997 Ottawa Convention that is on use of stockpiling, production, and transfer of anti-personnel landmines and on their destruction. Anti-personnel landmines, it forbids or it bans anti-personnel landmines in Ottawa Convention. Usually referred as anti-personnel mine ban treaty. This international agreement bans anti-personnel. Yes, these are anti-personnel mine ban treaty. This convention requires state parties to destroy the stockpiles anti-personnel mines. So if you are signatories to the conventions, then you have to destroy the stockpile mine within 4 years, to eliminate the holdings including mines currently planted in the soil within 10 years. The key current and past producers and users of landmines including the US, China, India, Pakistan and Russia have not signatories to the treaty. Right? So US, China, India, Pakistan, US, China, India, Pakistan, Russia are not signatory to the Ottawa Convention. So what Ottawa Convention, remember, it is regarding Ottawa Convention is regarding the it is banning the butterfly mines. India has not joined the treaty. Its main reservation is being legitimate national security concerns. Right, legitimate national security concerns. We have legitimate national security concerns. There are both two nuclear powers. There are rogue state like Pakistan. It is Afghanistan is also failed state. So it is India has also. So these are the reasons why there are various attacks on India from both in 1962, 1964, and in 1971 in Kargil war. So there are multiple wars that are initiated by our countries like China, which is an aggressive state, and Pakistan, which is a rogue state. In such a situation, India cannot afford to sign all these types of butterfly mines treaty or Ottawa Convention, because there is a security threat from both the countries and the neighboring countries. Beijing swift. What is Beijing swift? The swifts are a family Apodidae, highly aerial birds. These are birds. Apodidae, aerial birds are the Beijing swifts. They are superficially similar to swallows but are not clearly related to any passerine species. The swifts are placed in order of apodiforms with hummingbirds. So it's one type of aerial bird, highly aerial birds. These are Beijing swift. Swifts color on all the continents except America. These swifts occur in all the continents except Antarctica, but not in the far north, large deserts, or may in oceanic islands. So in every areas it is seen that is Beijing swift, highly aerial birds. The swifts of temperature regions are strongly migratory and winter in the the swifts of temperate regions are strongly migratory and winter in the tropics. So they are migratory birds, especially these Beijing swifts are migratory birds. Some species can survive short periods of cold weather by entering torpor, a state similar to hibernation. Short period of cold weather by entering torpor, a state similar to hibernation. So some species can stay in the cold period, right? That is called as torpor. Hibernation means sleeping during the every cold days. That is sleeping. That is hibernation. And these birds, they also undergo sleeping. One type of sleeping, that is called as torpor. It is Beijing swift, which is high aerial birds. No swift species has become extinct since 1960, but BirdLife International has assessed the Guan swiftlet and endangered and list Etiu, dark-rumped Seychelles and Tahiti swiftlets are vulnerable. So some particular species are vulnerable and Guam swiftlets are endangered. So swift species are not endangered, but some particular species of within that swift species are endangered. Okay. So 12 other species are near threatened or lack sufficient data for classification. There are other 12 species of swift species that do not have any such data. The Beijing swifts, which are bred on the summer palace in Beijing, travel more than 13,000 kilometers to spend winter in the southern Africa before returning to the following spring. Right? They can move up to 13,000 kilometers, right, to spend winter in the southern Africa. In its lifetime, average Beijing swift will cover migration distance around 1,80,000. That is why it is called as Beijing swift. Aerial birds, right? They can cover around 1,80,000 kilometers, about half the distance from Earth to Moon. These iconic birds, synonymous with Beijing since 1417, when they made their nests in the original city gates house, arrive Beijing in April. After bedding, begin their long journey to Africa in the late July. Why they are synonymous with Beijing? Why Beijing swift? Because when they made their nest in the original city gate houses, arrive Beijing in April. Right? They make their nest in the original Beijing city. That's why they are called as Beijing swift. They take a route that first lead to northwest to Mongolia, and from there they pass north of the Xianshan mountains, and then south through the Iran, Central Asia, Central Arabia and tropical Africa, before spending 3 months in the winter Namibia and Western Cape. So these are the regions that covered, huge amount of region they covered Beijing swifts. They begin the return journey in February, retracing a similar route, arriving in Beijing in mid-April. A journey that sees them across about 20 borders. So they arrive in the Beijing in the mid-April. That's why they are called as Beijing swifts. Beijing swifts. They are called as Beijing swifts. Next, this is the main question. What is wetland? Explain the Ramsar concept of wise use in the context of wetland conservation, and cite 2 examples of Ramsar sites from India. Now the Ramsar sites has increased to 64. Just before 6 months it was 49. Again it increased to 5. It became 54. Again recently last week it has increased to another 10. That is 64. The government of India targets to make around 75 Ramsar sites. Ramsar Site Transfer Convention, it was started in 1971 for conservation of wetlands of international importance. Those wetlands which are of international importance, their conservation will be primarily focused by this Ramsar Convention. The wetlands are defined as the areas of marsh, fen or peat and water, whether natural or artificial or permanent. See, these are marshy region, fen or peat land region, water region, natural or artificial, or temporary or permanent, with water that is static or flowing, fresh or brackish, salt, includes area of marine water, the depth of which low tide does not exceed 6 meters. The depth of which at low tide does not exceed 6 meters, that can be called as a wetland. Wetlands are areas of intermediate between the deep water and terrestrial habitats. Deep water and terrestrial habitats. These habitats experience periodic flooding from adjacent deep water habitats. There is right adjacent deep, for example, there is Chilka Lake. Chilka Lake is associated with our Bay of Bengal. It is a brackish water lagoon. So as it is adjacent to the sea, so regularly there will be influx of water from the sea. Right, these habitats therefore support plants and animals specifically adapted to shallow flooding or water logging of the substrate. Right. So they support huge amount of biodiversity. Okay. Then Ramsar concept of wise use are the center of Ramsar Convention. Philosophy is wise use of wetlands. What is this wise use? How it can be beneficial for human being? Now we have to. The goal of this present time is that simultaneously we have to think about the economic development of the developing nations, right? Rising of poverty and development of infrastructure. At the same time, we have to also think about the environment. That is, our development should be sustainable development. So how can we wisely use the wetlands? The convention defines wise use of wetlands as the maintenance of their ecological character. Right, their ecological character need to be maintained, achieved through the implementation of ecosystem approaches within the context of sustainable development. Wise use can thus be seen as a conservation and sustainable use of wetlands and all the services they provide for the benefit of people and the nature. Wise use of these wetlands, that is sustainable development of wetlands, so that they provide the benefit to the people and the nature. Indirectly, they help a lot to the people, right? For example, fishery, for example, development of biodiversity, maintaining the food chain. Right? Maintaining food chain is very important concept. Once it gets disturbed, then whole food chain will get disturbed. Ultimately, the various species in the biodiversity will get extinct. Just a second. In 1990, the contracting parties adopted guidelines for the implementation of wise use concept, which emphasizes on importance of the wetland. What is this wise use concept? Adopting national wetland policies. Each government should have national wetland policies, either separated or as a component of wider initiatives such as national environmental action plans. Every country has national environmental action plan, right? How our development should proceed. We should not, for example, many times court interfere and they bar the state government to encroach the wetlands areas because they restore our biodiversity. They comprise of various species, so that should not be restricted for developmental purposes. But in urban areas, wherever we see some such marshy lands, because of urbanization, industrialization, many times these wetlands they are filled and their infrastructure developed in the wetland areas. That is the issue. That is the major issue. And many times we see in the urban areas such type of development are happening. Developing programs covering wetland inventory, monitoring, research, training, education, and public awareness. Right? The awareness about wetlands. Is need to be there. Should be public awareness. Usually, public awareness is there for trees, for plantation. For public awareness for wetlands is not there. They just think that is useless area, right? Where there is accumulation of waters, and that is not a good thing. So public do not realize the importance of wetlands especially. They understand about the plantation, but not about wetlands. That need to be. So awareness generation is also essential part regarding the conservation of wetlands. Taking action of wetland site involving development of integrated management plans covering every aspect of the wetlands in the relationship with the catchments. How they are integrated to the food chain, how they are integrated to the environment, that is very complex and that need to awareness should be generated among the masses for their conservation. Then Ramsar sites from India. There are various Ramsar sites. For example, Loktek Lake, Manipur was included in the Montreux record of Ramsar Convention 1993. As a result of ecological problems such as deforestation in the catchment area, infestation of water hyacinth, and pollution. Water hyacinth. Water hyacinth means this is a invasive species. If water hyacinth that enters a particular wetland, it destroys all other the wetlands and it covers the wetland fully, right? Water hyacinth, that is an invasive species, that is hampers the wetland. And also deforestation for urbanization or for development of human civilization. Deforestation is also the problem. Koradio National Park, Rajasthan has blazed the Montreux records in 1990 due to water shortage and unbalanced grazing regime around it. Unbalanced grazing record, that's why it is called as, it is placed in the Montreux record. That means now after mentioning in this Montreux record, generally the conservation increases, right? There is international monitoring of such type of wetlands. Now we will go for the main topic. What is the Criminal Procedure Identification Act 2022? Criminal Procedure Identification Act. The Criminal Procedure Identification Act 2022 provides legal sanction to law enforcement agencies for taking measurements of the convicts and other persons for the purpose of identification and investigation of the criminal matters. While the legislation was enacted earlier this year, the Ministry of Home Affairs notified it to come into effect from August 4, 2022. It also repeats the existing Identification of Prisoners Act of 1920. Right? The existing Prisoners Act of 1930 is abolished, and the new Criminal Procedure Identification Act 2022 it has started. What is the purpose of this act? Earlier, for example, that in our K. Putasamy case of Supreme Court said that right to privacy is a fundamental right, and that your data should not be shared with any person. State cannot ask about your biometric or other iris scan, for example. All this data state cannot ask immediately from the investigation. Only was happening after the order of the court. But in such a situation, now Parliament has given the power to the executive, especially the law enforcement agencies or the police, to take your biometric data, your iris scan, and whatever the measurements they want to, that will help them for the criminal records, they can take it. What is the use of identification details in criminal trials? Measurements, photographs for identification have three main purposes. First, to establish the identity of the culprit against the person being arrested. Second, to identify suspected repetition of similar offences by the same person. And third, to establish a previous conviction. Right? Previous conviction, where it is to gather the evidences. It is also essential, right? To establish identity of the culprit. Who is the culprit? It can be matched. For example, in one place you find some fingerprints, and you have a fingerprints of a huge number of criminals. They can be matched with the fingerprints of other criminals. Right? Second, identify suspected repetition. Suspected repetition, because many times the same criminals are conduct similar type of crimes. Who is the expert? For example, somebody is stealing bike. Obviously, he will be expert in stealing bike. So that can be matched. What are the previous Identification of Prisoners Act 1920, which was repealed? Even though police has powers of arrest, mere arrest doesn't give them the right to search a person. As the earlier Prisoners Act, they do not have the right to search a person. The police require legal sanction to search the person and collect evidence. Legal sanction, that means it was given by the court. The court will direct the police to collect the evidence. These legal sanctions are designed as to maintain a balance between rights of the individual and the interests of the society, prosecution and prevention of offences. Right? Earlier this was balanced, which was to balance between the rights of individual, whether a individual do have the right to give his consent regarding this, regarding his fingerprints or photograph or any other things. At the same time, we have to also think about the health of the society, about the interest of the society. So now this Prisoners Act, it was not giving mandate, it was asking for a legal sanction, especially from a magistrate or a court. The Identification of Prisoners Act 1920 became necessity when the recording of newer forms of evidence such as fingerprints, footprints, measurements started becoming more accurate and reliable, right? Why it is essential? Now the footprints and measurements started becoming more accurate and reliable. For example, now we have Aadhaar Act, now we have Aadhaar, then where we are also giving our details. So in such a situation, it will be easy to catch a particular person. To catch a particular person, it will be easy. Statement of objectives and reasons of the Identification of Prisoners Act 1920 stated that the value of a scientific use of finger impressions and photographs as agents in the detection of crime and identification of criminals is well known. Right? It was well known, that is detection of finger impression and photographs. It further goes into state that although lack of legal sanction is not created problems before, there are increasing instances of prisoners refusing to allow their fingerprints. Right? Now fingerprints, many prisoners, they are refusing their or allowing the law enforcement agencies to give their fingerprints, and that creates the problem, right? Which is a normal incident of police work in India. As well as on a regular footing, it considered necessary to enact the Identification of Prisoners Act. So as they are refusing many times, those persons who are accused of a particular offences, they refuse to give their photographs or fingerprints. That's why it has become necessary for the government to take it. Over the years, the need to amend or update the Identification of Prisoners Act 1920 has been voiced several times. In 1987 report of Law Commission of India, in its 87th report, you should mention this, Law Commission report in India, in 87th report, undertook a review of the legislation and recommend several amendments done in the backdrop of the state of UP and Rambabu Mishra case, where Supreme Court has highlighted the need for amending this law. In the state of UP versus Rambabu Mishra, the Supreme Court has highlighted the need for amending this law. It is also given by the 87th report of Law Commission to replace the Act of 1920. The first set of recommendations laid out by the need to amend the Act to expand the scope of measures to include palm impressions, specimen of signature or writing, and a specimen of voice. All these things need to be signature or writing, a specimen of voice. The set of recommendation is was given. This need to be taken by the police officers or the law enforcement agents. The second set of recommendation raised the need for allowing measurements to be taken for the proceedings other than those under criminal, that is Code of Criminal Procedure. Raised the need for allowing measurements to be taken other than those under the CRPC. The Law Commission report also notes that need for amendment is reflected by the numerous amendments made by the Act in several states. Various states have also taken steps like that, right? Because state is a law and order, so the law and order issue is a state subject, and various states they have taken such type of steps. The Minister of Home Affairs, while laying the Criminal Procedure Identification Bill 2022, Lok Sabha observed that with advancements of forensics, there need to recognize more kinds of measurements that can be used in the law enforcement agencies for investigation. Right? As the forensic science is developing, the criminal procedures, the criminal identification science is developing. So there should be more measurements, so that and those measurements and police have the right to take those measurements. What are the main highlights and differences in both the legislations? Highlights and differences in both the legislation. Like the Identification of Prisoners Act 1920, the Criminal Procedure Identification Act 2022 provides for legal sanction to law enforcement agencies to collection of the measurements. So this Identification of Prisoners Act 1920, the new criminal procedure, so it provides a legal sanction. That means earlier, now they do not have to take their permission from the court or the or magistrate. They can do it there itself. So that provides legal sanction to the police officers. While at the state level, each state is required to notify the appropriate agency to preserve this database of the measurements. So they have to inform the appropriate agency in every state to preserve this database or to preserve this information. At the national level, National Crime Records Bureau is a designated agency. National Crime Record Bureau will safeguard this type of information at the central level. So what is changed? What is changed in the Identification of Prisoners Act? In case of prisoners who would be convicted of an offence punishable with rigorous imprisonment for 1 year or upwards under any law, right? Yes, here convicted will be if convicted of an offence punishable. Yes, if he is punishable more than 1 year, then his measurements can be taken, right? But in case of prisoners, Identification of Prisoners Act, but here if it may be any type of wrong, his identification can be taken. For example, somebody is doing a certain time with a punishment of 6 months, still his offences can be taken under still his offences, still his measurements can be taken. Okay, next, if directed by magistrate or measurements to be taken for the purpose investigation proceeding the CRPC, provided the person has been arrested in connection with investigation previously, ordered to give security to his good behavior under the CRPC. So here in case of Identification of Prisoners Act, the police has to take the permission of the magistrate for proceedings of regarding the data of a particular convict. But here arrested of an offence punishable under any law, if detained under preventive detention laws, even if under preventive detention laws, even if arrested on a offence punishable under any law, he can directed by the magistrate measurement to be taken for the purpose of investigation proceedings under CRPC. There is no requirement for the person to have been arrested in the connection with such proceeding previously. So even if there is no such proceeding, even if there is no history of criminal records, still the details of the convict can also be taken. Measurements that can be taken: finger impression, foot impressions, measurement and photographs. Here multiple: finger impression, palm print impression, footprint impression, photographs, iris, retina scans, physical, biological samples, their analysis, behavioral attributes, including signature, handwriting and any other examination, refer to section 53 or section 53 of CRPC 1973. Then destruction of measurements. In case of acquittal, discharge or release, it is not previously convicted of any offence, then of or 1 year, more than 1 year, then they are allowed for destruction of the measurements, right? Earlier it was allowed if it is released or if it is not punished or it is acquitted, then destruction may be allowed. Or in case of acquittal, discharge or release, if not previously convicted of any offence punishable with rigorous imprisonment for any term, for convicts, records are to be destroyed from 70 years of collection, right? After 70 years of the collection, records will be destroyed, otherwise records will be preserved. What are some concerns of the present legislation? The Identification of Prisoners Act 1920 was a colonial legislation. It is a colonial legislation. It is duplication of the Criminal Procedure Identification Act 2000. Its duplication in the Criminal Procedure Identification 2022, a post-independence legislation has raised some concerns regarding the protection of fundamental rights, because we see right to privacy is a fundamental right, and state do not have any jurisdiction to take care of that right to privacy. The legislation comes in a backdrop of right to privacy being recognized as a fundamental right, right in the K. Puttoswamy case. The fundamental facet right is protection from the invasion of one's physical privacy. So it is one type of physical privacy when another person has all the data regarding your fingerprint and any other information. As per Puttoswamy judgment, for a primary privacy intrusive measure to be constitutional, there is no need for a measure to be taken in pursuance of a legitimate aim of the state, backed by the law and to be necessary and proportionate aim being sought to be achieved. In this case, while the first two tests are satisfied, prevention and investigation crime is a legitimate aim of the state, and measurements are being taken under valid legislation. The satisfaction of the third state is necessary and proportionality has to be changed on the multiple counts. So we cannot make a watertight segregation, and we cannot say that the right to privacy cannot be impeached or right to privacy cannot be intruded by any other law, because for larger purpose of the society, for prevention of the crime, investigation crime, it has to be the law enforcement agency, they has to use the information or the biometrics or the photograph or the palm prints, all these things steps they can take. While the need for expansion of the measurements that can be taken is well justified, the inclusion of derivative data such as analysis and behavior attributes have raised the concerns that data processing may go beyond recording the core measurements. So it is not beyond, there is behavioral attributes also can be taken by the law enforcement agencies. So it is not only measurements, that is, it is more than that. Some of these measurements could be processed for predictive policing. Predictive policing means based on prediction that this person might has called the violence or the crime, that thing will be that will be more and more. While this is a legitimate concern, the purpose for which the measurements can be processed need to be better defined. Merely recording core measurements without conducting the required forensics on them would severely limit the usability of the measurements. So that will only better recording the core measurements, right, conducting the required forensics on them. So we have to develop the forensic system as well. Without developing the forensic system, it will be almost useless, right? So that's the parallel development of other technological advancements with respect to criminal procedure. Second, unlike the Identification Prisoners Act 1920, which provided that measurements will be taken either convicted or arrested of the offences that entail imprisonment of 1 year or upwards, right? Earlier there was that there should be imprisonment of 1 year, then only you can take the details of the particular person. Should be for any including petty offences. The necessary, but now the current law, measurements can be taken for petty offences, right? Even if you do any single offences, then that measurements can be taken. The necessity of taking measurements of such persons for investigation is unclear. Why it is necessary? If a person is not doing a severe crime, it is a minor crime, why it had become necessary to take the details of that particular person as well? He is not a grave threat to the society. The necessity of taking measurements of such person for investigation offence is unclear. Such discretion is likely to result in abuse of the law and lower levels and overburdening of the systems used in the collection and storage and measurements. So there will be overburdening of the systems also, because huge amount of data need to be stored. And given that these records to be stored for 75 years from the time of collection, so it will require huge amount of data structure to save those data up to 75 years of the collection. The new legislation allows person who has been arrested for an offence that is punishable by less than 7 years imprisonment. It is not offence against women and children, may not be obliged or allowed taking his biological samples, right? If that offence is not against children and women, then he is not obliged to take his biological samples. He may oppose it, or the enforcement agencies will also agree with him. This is definitely improvement over the earlier law, which did not allow any such refusal, right? It is also helps allay concerns of disproportionate collection. However, given the option not to submit in measurements is limited. Biological samples and are available at the discretion of the police officer. This exception provides restricted relief. So, biological samples is available at the discretion of the police officer. Yes. So, if a particular person is not getting punishment, that is more than 7 years, or his crime is not against women or children, then he is not bound to give his biological samples. Another worry is expressed by experts is that collection can also result in mass surveillance. There will be mass surveillance. The data of all the masses will be in the hand of police, with the database under the law being combined with other databases such as those with crime and crime and criminal tracking network systems. So when databases will mix, that will violate the right to privacy, and that is one type of surveillance of each and every persons. Lastly, concerns are being raised that the present law violates the right against self-incrimination enshrined in the Article 220 in the Constitution of India. Self-incrimination means giving evidence in the support or against itself, right? That is self-incrimination, or forcing you to give evidence against yourself. However, this argument is nebulous since the Supreme Court has already settled the point. In the state of Bombay and Kathikalu Ogad, Supreme Court had said that non-communicative evidence, that is evidence which does not convey information within personal knowledge of the accused, cannot understand leading to self-incrimination. Non-communicative, only when you don't speak, that cannot be taken as self-incrimination. Therefore, no challenge lies to the law in this ground. So, Supreme Court has made it clear. So, what need to be done? The opposition has raised objections to the law to import or not being submitted for public consultation or referred to Parliamentary Standing Committee. As the dawn of the DNA technology, use of application regulation bill which is benefited from such scrutiny. So there will be DNA technology use and regulation bill, right? In this regard also opposition has raised some issues. The central government responded to the criticism of the law that setting the privacy and data protection related concerns will be addressed in the rules formulated under the legislation and through the model prison manuals and state can refer to. So the central government is making the laws on the basis of B.N.C. Krishna committee. So those recommendations will be adhered to. So on the basis of that they will make the prison manuals. The immediate future of this law is unclear. A writ petition has been filed challenging the constitutionality of the law before the Delhi High Court. The court has issued notice to the central government for filing a reply, right? So there is also legal challenges that is arising with this law. If that fails, then that law can be declared as ultra vires or violative of constitution. So the lectures end now, and like this video, share this video and subscribe to VANIK-IAS. Thank you.